Swayam Prabha. Digital India. Educated India.
So friends, continuing from the discussion, now probably we should try and understand the background to the governance or public administration framework through the one enactment of the Constitution and probably to the working of the Constitution as well. So this will be the introductory part of this course. And before we go forward and understand the Constitution of India, the right way of saying it is the Constitution of India, not the Indian Constitution. But nevertheless, I think whenever you use that interchangeably sometimes, I think it means that we are referring to the Constitution of India. So you will notice that Constitution is the kind of basic framework that is required to bring about administration, in particular public administration, in countries across the world. And hence, countries that can be called as, say, countries like which are governed by a single party system, like the Communist Party of China, may also have a constitution. India, being the largest democracy of the world, also has a constitution. So constitution then, becomes the fundamental law of governance for countries. And the Indian constitution was one such attempt that was made, before we became an independent republic. Now, why should we understand the different types and characters of a constitution is because it gives us a kind of an idea about, why did we have a constitution like we have right now? Because, you have to look at the different types of constitutions to choose very wisely which is the most proper and appropriate constitution for India, isn't it? So, knowing the types of constitution is very, very important. And hence, you will notice that historically, constitutions were generally enacted. Like the Indian constitution is an enacted constitution. We enacted it, we gave it to ourselves. There was a drafting committee, there was a constituent assembly. And it was actually brought into effect. And that's how we say it is enacted. So we say that the Constitution of India is an enacted constitution. However, you will notice that in certain other countries, the constitution is an evolved constitution. The best example for an evolved constitution is probably the British Constitution. Because the British Constitution has evolved over a period of a long duration of time, probably more than 4 to 5 centuries have gone into the evolution of the British Constitution, which actually should get the credit for the parliamentary form of democracy that it gave to the world. So evolution is a kind of very interesting process of change, because you don't have an enacted constitution per se, but you believe that a constitution evolves over a period of time about how the governance structure in a country should be made about through experiences and through several other instruments that actually frame the fundamental law of the land. So in Britain, though you are talking about what is the form of the constitution, you will notice that in Britain it's an unwritten constitution, basically. It is through precedent, it is through practice, it is through custom, it is through evolution of times that they understand that this is the constitutional process in Britain. So that makes this quite an interesting issue, because could India have adopted an constitution that could have evolved through the kind of experiences of the country? The answer is no, simply because we had to gain independence from the Britishers, and we had to actually look at government to rule and to enact the different legislation that were required. And the constitution should have been the framework for the power structure that had to be brought into force at that point of time. So India could not have looked at an evolutionary history to make its constitution. I think we had to get into the enactment mode. However, you notice that the Indian constitution did take at least a year to actually get finalized. And hence, you may say that it was an year of evolution for the constitution to come in place. So, I think historically, when you apply the way in which constitution comes into place, this is the distinction between an enacted constitution and a evolved constitution. Now, the Indian constitution is a written constitution. Of course, it is very clear. It is probably one of the largest written constitutions in the world. Nevertheless, I think we go by the text of the constitution. Everything is in black letter of the law. There is a lot to do with what is written, because you please note that written constitutions also go by what we call as interpretation rules as well. We have what is known as statutory interpretation or constitutional interpretation. We have so many doctrines to the way the written constitution should be read into. And I think the written constitution has its own advantages. Sometimes it may have its own disadvantages. Because you will notice that when you go to the next part of structure, you will notice the written constitution seems to be rigid. When I use the word seems to be rigid, I clearly mean that. And an unwritten constitution gives you all that kind of flexibility. Because, when we say that evolution of a constitution is so critical and important, because, there are different generations during these, few centuries in Britain. And every generation probably had its own aspirations to see what should be the basic framework of governance and how should the constitution look like. So the constitution has to be evolutionary in character, though not revolutionary through. But nevertheless, I think written constitutions tend to be rigid, like the American Constitution is so rigid, and changes to the American constitutions are very rare, though it's a very short constitution. And you will notice that the structure of a written constitution can be balanced between rigidity and flexibility. For example, in India, though we have a written constitution, the basic structure doctrine brings in the structural balance of rigidity versus flexibility. While we say that you can't totally change or amend the constitution entirely, because the basic structure has to remain the same, but the flexibility is required because the constitution, once drafted, has to undergo some kind of a change. That is an inevitable part of the journey, right? Change is very important. Law cannot be constant, and constitutional law is the fundamental law. It cannot be constant. And I think the difficulties that arise over a period of time, or the experiences that are gained over a period of time, I think the constitution must adequately reflect the same. So, on the structure, I think many constitutions are attempted to be flexible. You will notice that some of the constitutions do say that the constitution can be rewritten once in 18 years. Because they believe that once in 18 years, a new generation of people are in the society, and every generation must decide what is the constitution that they require. So I think constitutions tend to be flexible, but not entirely. They have to have some form of rigidity. That's the best rule forward or the thumb rule forward. Because if you try and tamper with the constitution time and again or too very often, then in that extent, then the very significance of having a constitution as the basic norm of the foundational law to govern gets entirely disturbed. So I think a balance between rigidity and flexibility is usually what is being attempted in most of the countries. But you will notice that some countries, do get into a very rigid framework, and amendments to the constitution are hardly possible. Now, please note that the basic structure doctrine in India is actually a very celebrated doctrine. We just completed 50 years of this doctrine very recently in the Keshavananda Bharati case. And you will notice that it is very important to understand that basic structure doctrine vis-a-vis India, and how this doctrine has probably influenced the world over in terms of the balance of the rigidity versus flexibility structure. Finally, friends, the type of the constitution is also based on what kind of government it creates. Right? So, usually constitutions tend to create a very federal kind of a government. Federal government does not mean that it has only single government. A unitary kind of a constitution creates a single government. like we have it in Britain right now. Britain actually has a unitary form of government in its unwritten constitution. Whereas in India, we have a federal government, but we also have a state government. And interestingly, we have also the local governments of these countries. So the constitution actually in India has a three-tier system of governance. So it's not a constitution just focusing on the powers of only one institution, which is the central or the federal government institution. So the reason why this type of constitution is important for us to understand is because, Britain is a small country, so it can have one government. India is a big country, we may need three tiers or three levels of government. Now, once there are three levels of government, please note, friends, the constitution inevitably gets longer because the constitution is the document that actually defines and lays down the powers of the government. Right? That is one of the functions of the constitution. So please note, the Indian constitution has to state what the central government can do and cannot do. When it says cannot do, it means what has not been stated as your power, you cannot probably exercise it. Then it has to state the same about the state government. And finally, you will notice that post 1992, the 73rd and 74th Amendment to the Constitution, we have also to lay down the powers and functions of the local government. Interestingly, even in the local governments, we have a three-tier system of governance as well. So that is the difference between a federal and a unitary type of a constitution that creates a government. A unitary constitution is a single government constitution, so it can state the basics in short, and that could be the basis of understanding how the constitution is. So the next point for us to take into consideration is what functions are generally carried out for a constitution. What should the constitution contain, probably, and what functionalities does the constitution perform? One thing is that, of course, constitution lays down the framework of governance and government. Only when you have government, you can have governance. What does the constitution do? It tells you, look, when we want government, and please note, when we say government, we are saying all the three tiers of the government. Be it the legislature that is supposed to make the law, the executive that is supposed to implement the law, or effectively bring about what I would call as public administration, or the judiciary, which should adjudicate disputes among citizens and among various other stakeholders. So the form of the judiciary, the form of executive, the form of the legislature is something that the Constitution gives as a matter of prescription. Right? So the Constitution is, to be honest, a prescriptive kind of a document. And it lays down the form, the structure, the powers of governance, and government functionality is something that is stated in the Constitution. Second, the Constitution is not only about government, but also what does the government govern on, or whom do the government govern on. Of course, it is the people, it is the citizens, it is the community, it is the society. That is what the government is supposed to do, and that's what the government is actually formed for, and it is the purpose of the government to actually govern its people, right? That's what is statehood, it is country, it is the society, and hence the rights of the citizen vis-a-vis the government, right? Because please note, the government does not have legitimacy unless the people recognize it as a government. So legitimacy of any constitution comes from the recognition of its people in terms of the power of the government that is being created. So the people-centric approach to constitution very clearly will make the constitution speak about what we call as the fundamental rights. Now, interestingly, friends, in the world, as we speak, both internationally as well as nationally, there are different rights that citizens have to have. We are human beings, and human beings are entitled to what we call as human rights. Now, human rights can be divided generally into some kind of rights that are, completely natural to you. As soon as you are born as a human being, you must have right to life. These are, nature-given rights, and the Constitution must recognize the same. But while we talk about different kinds of rights, you will notice that some of these rights can be just legal rights. Now, a legal right is something that is given to you by the statute, but a fundamental right is generally given to you by the Constitution, because Constitution is a fundamental law, and hence, if the Constitution gives you certain rights, they are considered very fundamental. They are considered very essential, as against just a simple mere legal right. So constitutions usually speak about what are the fundamental, something that are non-compromisable, something that cannot be alienated, something that requires the highest amount of protection, least amount of interference from the government, are so-called the fundamental rights. And fundamental rights are also something that are stated in most constitutions, because that is what the constitution does. It not only talks about government and its governance, but also on who the people are matters that the government is supposed to administer on. Some of the constitution interestingly also talk about what should be the direction of policy making in the country. For example, in India, chapter 4, which talks about the directive principles of state policy, speak about the kind of direction state must take when it makes legislations. Right? So you will notice that it is important, because very often than not, we have always said that the constitution is supposed to be a vision document. It is supposed to be a futuristic document. It's supposed to tell you where the nation must progress or be, and what is the aspiration of the people of the nation. The constitution actually reflects those aspirations as well. And hence, what kind of state policies must be driven to achieve those aspirations, and what kind of legislations are permissible and not permissible. Sometimes the constitution can lay it down. Interestingly, the legislations are not as per the constitutional vision or the basic premise of the constitution. Generally, you will notice that the constitutional courts may hold that legislation to be unconstitutional, which very clearly says, in the terms of the fact that, look, this is a legislation that does not, resonate with the aspirations of the constitution. It is against the vision of the constitution. It is against the basic principles of the constitution, and hence it violates the constitutional norm, and hence the legislations can be held to be unconstitutional as well. So the test of the constitution for any legislation is a must. The constitutionality is a must. Similarly, we talk about administration. The constitutionality of any administrative action is supposed to be tested, because that's what the constitution is supposed to do, right? Because the functions of the constitution, friends, is also to limit the power of the government. So while you talk about the form of the government, the powers of the government, it is also to limit what they can do and what they should not do, right? Because as soon as the constitution gives certain kinds of powers to the three organs of the government, these powers, the constitution has to anticipate the kind of risk. Maybe they are going to be abused, or maybe there is going to be overuse of the powers, and hence the limit to the power is something that the constitution has to also decide and lay down. Now, when we talk about the limits of government, one of the examples that many of you would want to refer to is, you do not want the central government to enter into the state government's domain. That is the limit of government, right? So, constitution must define the role for each organ, both federally, at the state, and also at the local level. So, several functions of the government can be laid down in the constitution. How should the government execute these schemes, ideas of welfare? Because most states would want to call them as welfare states. So how can the constitution lay down the same? And finally, you will notice that the separation of power doctrine is something that the constitution tries or attempts to do. Though the doctrine of separation of power cannot be strictly adhered to, because the doctrine of separation of power says that the legislature is only supposed to do legislation, right? They're separate. They have to only keep in their domain. The executive are supposed to only implement the law, and the judges are supposed to. So unless the three organs are separated, they will be in conflict with each other. And that's not a healthy constitution at all. So the constitution must demarcate the role that each of the functionaries under the constitution must perform very clearly, so that each organ knows precisely exactly what they're supposed to do, and I, as the judiciary, does not enter into the domain of the legislature. However, friends, the strict doctrine of separation of power is, which said that the legislature only should do the law and they cannot decide this. That is something, unfortunately, not adhered to, though the constitution does attempt to do it. So right now, if you ask me, the doctrine of separation of power in the constitution may look something like this. The three circles, but each of the three circles actually touch the ring, right? So the three circles, because the legislature sometimes does adjudication, the judiciary makes the law many a times, And the executive also is making legislations, which we call as delegated legislations. To be honest, friends, today the executive lawmaking is quite enormous because Parliament only enacts acts. They only make the substantive law. But the procedural law, which are in the forms of rules, regulations, bylaws, notifications, all are made by the executive. So this is delegated power by the Parliament to the executive to make the law. So it's not strict separation of power. I think each of them can do a little bit in the other space, but respecting the basics, functioning of the other organ. Now, for example, on many occasions, the Supreme Court has refused to enter the policy domain of the government, saying that that is the domain of either the executive or the legislature. So the Supreme Court has said, we will refrain. This is not what we need to do. This is left to the legislature and to the executive, and hence we will not entertain or enter into that. So these are the kind of functions that is expected from a constitution, and you'll probably look at each of these functions as we take this course forward and try and read about the constitution. Now, bringing in the relationship between public administration and constitution, is there an interlink, and why is this course trying to bring an interface between the two? Is for the simple reason, friends, is, when you talk about the word public, as I told you in the past, public administration, it is not private administration, it is administration vis-a-vis what you do outside the domain of your home, in the society. It affects individuals in the society, it affects community. So, to be honest, friends, the three organs of the government are nothing but into public administration. The legislature is supposed to make law for the public. How they make the law, how they administer it, what is their vision for administration? Is it a top-down approach? What is a top-down approach? That I make a law irrespective of consulting my stakeholders. Or is it a bottom-up approach where I want to consult stakeholders, I want to consult affected individuals, and only then enact the law? That is also part of public administration. So, public administration is nothing but a process of an organized management of, state bodies, if you ask me. So, there are state agencies, there are state departments, there are state ministries, there are so many departments of the government that are actually, for example, let us just take public administration and police. See, the police is a very important, agency maintaining law and order in a society. Please note, the Constitution's main vision, if you ask me, is to maintain peace, tranquility, and harmony in the society, where every person is able to achieve his own intellectual, creativity, to achieve his own basis of, his growth, his ability to express himself creatively or otherwise. This is what the Constitution must give. Sometimes we always talk about whether a Constitution is a happy Constitution or not. So public administration actually reflects the spirit of the Constitution. In one sense, how do the members of the government, please note, government does not have a face of its own. Government means what? Legislature means what? Legislature means the Prime Minister, the Cabinet, the party in power, the opposition. Legislature means the Parliament, Lok Sabha, Rajya Sabha, all combined together. So when we say government, it is about people who administer the governments. It is Constitution who makes the Constitution work, are the constitutional bodies. So when you talk about public administration, we are talking about this Constitution that has created the functionality of certain bodies and how they would actually affect the general public economically, socially, culturally, and all spheres of public life. Right? So when you talk about all spheres of public life, you will notice that the Indian Constitution has evolved over a period of time. Right? How does a citizen, for example, how does he feel safe in public life? I'm just giving you the action of police. So that becomes very important and relevant factor, and you will notice that we have taken more than half a century to take away the colonial legacy of what is the police power of the state. Is the police, or is it a police accountable to the people at large? So public administration and police governance is important, and the Constitution lays down what should these state bodies perform, how should they go about the process of management, regulation, and control. And that is what is also the main purpose of the Constitution. So, state power activity of the executive authorities is what public administration is all about. Right? State has power. There is an executive organ of the state that is supposed to carry on its function, and the whole discussion about the executive function of the government is usually called as public administration. But I believe that public administration is not just of the executive organ; it is also about the legislative and judicial organ, right? Because please know, when we talk about the executive authority of the state, appointment of judges, transfer of judges is also an executive function. It's not a judicial function. So public administration in the judiciary is also critical and important, right? And the constitution, how does the constitution speak about judges appointment, judges transfer? They also become a critical component of how the constitution is about to function. So, keeping the definition of public administration and relating it to the functionality of the constitution, please note the simplest definition would be it's a kind of a public power activity debate, right? Public to power, right? So power is there in the constitution. It has been given to certain state bodies. How does this power get exercised vis-a-vis the public? That is precisely what is the activity under public administration.